understand what a public is. The state in the public minister, a corp, a minister, and it represents the people's best interests. It has diplomatic status. Okay, and I want you to understand the concept behind it. A public minister has diplomatic status. Then the prosecutor, he acts as the state of diplomatic status public minister, right? Diplomatic agents. Diplomatic agents have diplomatic immunity. They 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 take advantage of consuls. Consuls are agents too. They're commercial agents. And this is, if you go to Article 3 of the Constitution, which talks about the court's power, they have the power to affect ambassadors, other public ministers, and consul, because the courts are dealing with consuls, public ministers, and ambassadors. Your private side is an ambassador that represents your best interest publicly, right? I mean, privately, but the state represents your best interest publicly. Person acts as a consul. Counsel is a commercial agent. It doesn't have diplomacy. A courtroom, when they person, what they do is they take the diplomatic agent. In this case, it will be the state of Minnesota, or the state of Michigan, or the city of, or it's the diplomatic agent. It's called the people of the state of Michigan, versus the counsel, which is James L. Murray, which is the name of the account there. They charged it, and they created an indictment, certified in all of these papers that they hear, because they know a nigga can't read all of this. But you have to understand the gist of what all of these pages they're saying nigga did such in order to anymore. But at the same time, they said all of these papers, the basic thing is they charge the statute somewhere, going back up to what pages where they talk about the statutes. It doesn't really make a difference unless you're trying to really get the money. Right, hold on a second. Then they charge these statutes in here. But when you understand the nature of it, this is a charging instrument. This charging instrument says, we caught a nigga by the toe. And what we're going to do is we're going to hold him. They booked him, they charged him. And so, and what it initially says, it says, this nigga has to be taxed. Right? Okay. Once they booked him and they charged him on this charging instrument. So now he has to make an understanding of what's going on in this case here. So when he understands that slavery is a good thing, it's not a bad thing if you're the slave owner. But now you have to register ownership. You have to register ownership. So now the first page on here is the first one going to a letter to the court clerk. The reason why this is going to the court clerk is to tell the court clerk exactly what you want done and how this case is to be handled. But before he do, and what the second page is, he's going to check the judge immediately. The second page, he's checking the judge. Okay. And if you're to read what to say, in the top right corner, it's indicating, see, in the heading of a case, like when you do a motion and stuff of this nature, it says the United States District Court, such and such county. That shows an authority in that particular case. Do you understand that? On an indictment or whatnot, it shows who's at the top heading or in the middle of the case, the side, it shows who's in authority in that case. But here, when you start understanding your diplomatic power or your diplomatic or your superiority, you're going to put entitled who's entitled to it in this case here. So he's entitled it. He said Murray James Earl. He's the one who's entitled. And guess who he's directing this to? He says 41B District Court, who's claiming title to his property. So he's going to clear this case is going to go down regarding case such and such. He's going to say this is regarding case such and such, and the police case file such and such, because they're saying when they sent him this case, they said we have this nigger, we caught this nigger, and this is going to have to pay out this interest on this case here. So what he's saying in this matter, so they're letting him know where his property is located, who's responsible for this case. So now he's going to direct this to the judge that's in this case, Jacob M. Flamingo, or whatever his name is, and the human being. He's going to make it abundantly clear that hey, there ain't no dispute in this because this case is already settled. What is he going to say here? Can you what he said? James says.
I, Mr. James L. Murray, a fully constitutionally empowered human being, surety on account of the above referenced case, hereby state, under the penalty of perjury, under the laws of the state of Michigan, the following. Number one, I tendered payment to the court administration for private settlement. See attached copy.
Stop. In each case, there's supposed to be payment. You remember what payment is. We're not saying we're trying to discharge debt and all this other stuff. I tendered payment. Payment is transfer. What is payment? It's the performance of an obligation, discharging an obligation. Discharging of giving something of value. So what he did is he transmitted to the court administration, who handles the administrative aspect of all criminal cases. When you go to court, what they're doing is they're adjudicating rights and wrong disputes. But if there's no right or if there's no wrongs or no disputes there, then you can handle this administratively, because I don't disagree with you. I don't care. I'm not the. You can't hold McDonald's responsible for something that Burger King did, unless McDonald's agrees to pay for Burger King's bill. But now, since he's the surety in this case, I'm just going to pay in a different way. And I want you to understand the science behind that. And since McDonald's, will look at it like this. Everyone's been to McDonald's before, right? Everyone's been to McDonald's. Well, right. You worked hard. You've been painting all day and stuff, and you got a paycheck, and you took your $2.50 out of your pocket. You took your $2.50 out of your pocket, and you purchased a Big Mac, right? So since you paid for the Big Mac by simply purchasing it with the $2.50 that you worked hard for, you got a Big Mac. And I looked at you and I'm like, damn, look at this dumbass nigga. He actually paid $2.50 for a Big Mac. If he would only went to the app, he would have saw a coupon for what? $2.50, which gave you a Big Mac. So after you paid for your Big Mac that you paid for, that you worked for, I went up there and I got I paid on my phone. Does that make sense?
Yes, sir.
Who paid for a Big Mac? Trick question. Who paid for the Big Mac?
I'm gonna let the floor decide.
McDonald's.
Somebody answer the question.
McDonald's.
Individual shirts. What particular situation? He gave him $2.50, and I pulled out a coupon. The question is, who paid?
Both.
Say that again.
Both.
That's correct. Both people paid, because we both gave him a medium that could cover the Big Mac.
Right.
See, though the coupon indicates that McDonald's owes the people something. So guess what they do? They give them these coupons, so now they could justify the return of that coupon, which indicates that they've given back to the people. So they can offset their tax liability with that coupon. Does that make sense? So I paid with my coupon, and you paid with your cash. So now here we got Ice. He's right behind me. He said, motherfucker, I ain't got to pay. I don't have to pay. Big Mac? No, because he's refusing payment. But now the bottom line is how you pay. The bottom line is how you pay. And when you start understanding how you pay, then you could better understand how to handle the court system. Why they charge the person instead of you. If we go back to the definition of an artificial person, the artificial person, when the definition, it says, hold on a second. Just a second. Artificial person. Artificial person. Okay, the definition of artificial person says that such as a corporation created by law and given certain legal rights and being, a being real or imaginary for the purpose of legal reason is treated more or less as a human being. And what they say here after the dot, it says an entity is a person for the purpose of due process and equal protection clause, but is not a citizen for the purposes, privileges, and immunities clause of Article 4, Section 2, which means with an account, time in prison to pay bill. But if you apply your exemption creates a credit offsetting the tax liability, just as if he paid.
Right.
If you let that resonate for a little bit. So you paid by doing labor, doing time in jail. I paid by claiming an exemption. Snipes, he didn't get anything because he didn't pay. He refused to pay. So now we're going to go back to this. We're going to go back to this where it says he's the surety. I, Mr. James Earl Murray, a fully constitutionally empowered human being. He's letting them know, look, bitch, I know what's going on here. I'm one of the people. I'm the surety on the account of this case. A surety is a payer. A surety is the one who's obligated to pay on the account. It says, I'm the surety on the account of the above referenced case. He's letting it be known, I'm the surety, I'm the one here to pay. A surety is not the person. Surety is the insurance company. He is not the person that's responsible. He is not the person that's responsible, but he is the person that's paying. Surety comes in here and there's this thing called, I don't know if any of you guys know the term called subrogation.
Right.
Any subrogation is?
Yes, sir.
I had to go to the hole for a long time and figure out one of those tortured missions that they sent me on to understand what subrogation means. Subrogation is a powerful word where it indicates a person, a surety who is secondary liable on an account and who pays is entitled to whatever the paying party was obligated to, and what the person who is obligated to get the payment is entitled to. So if you're to look up the word surety, you'll start to understand and look up the word subrogation. I subrogated to not the debtor's position, but also the creditor's position. So as the surety who paid, I see a little, you're furrowing your eyebrow. You got a question?
No, that was, if you could enlighten us more on the whole subject of subrogation, and maybe it'd be a little clearer.
Okay. Subrogation is an insurance concept. I don't know if you guys have ever been in an auto or been in an accident or whatnot, but I've been in myself. What happens is bumped into my cheap car, right? It was my car. It was worth a couple $1,000s. Well, the insurance, he had insurance. His insurance company was his surety. Since the value of my car wasn't that much, the Blue Book value said that it had to be totaled out. Since it being totaled out, the insurance company paid for the full value of the car. They paid off the liability. But since they paid off the liability, guess what they were entitled to? They were entitled to the car.
Mm-hmm.
It became their car, paid for it, because the value of the car was not there. So by subrogation, they paid off their insured's liability. And since I was the creditor in that situation, they were entitled to my interest in the car because they paid for the full value of the car.
Okay.
Does that make sense? Yeah. They paid for it. They gave me cash as the surety. So guess what they're entitled to? They're entitled to my car, and they're entitled to the premium that they're owed, the one who was liable for damaging my car, because they were the surety and they. Does that make sense?
Yes, sir.
Okay, now sincerity. Well, guess what? But insurance company, they're not in the business of keeping total cars. Right. So guess what they ended up doing? They offered me. They said, if you give us $, let you keep the car. But understanding the whole concept of subrogation, since they were the paying party, they are entitled to the car and the premium that the insured is still responsible to pay them. Does that make sense?
Yes, sir.
Okay, so now we're going to look at the fact that here you got a nigga. You got a nigga that they indicted this nigga.
Right.
And on this account, they're saying that this nigga owe $10,000 because he has this $10,000 bill, the charging instrument. Well, guess what I do? I use my exemption, which the artificial person can't do. I use my exemption to pay the bill. I return it to them and acting as a surety because I've given them my value of this obligation, which creates a credit on their books, which settles their liability on the account. Not only am I entitled to, I'm entitled to the property. I'm entitled to the property, the car, and any interest that's owed on that obligation as the surety by right of subrogation. Do you understand that? Because now I'm the insurance company.
It's
Well,
time,
I'm the insurance company.
it's time for me to go back to that dictionary and look up the official definition of the word subrogation, because I see I've been ill-informed along the way somewhere.
Okay, well, we'll look it up again. And then Black's Law Dictionary talks about equity of subrogation and right of subrogation. This is all in the Uniform Commercial Code, taxing code, and everything. What's a subrogation? Read the definition.
Subrogation, the substitution of one person in place of another with reference to a lawful claim, demand, or right, so that he who is substituted succeeds to the rights of the other in relation to the debt or claim and its rights, remedies, or securities. The lawful substitution of a party in place of a party having a claim against insurance companies, guarantors, and bonding companies generally have the right to step into the shoes of the party whom they compensate and sue any party whom the compensated party could have sued. The right of one who has paid an obligation which another should have paid to be indemnified by the other. Subrogation is of two kinds, either conventional or legal. The former being where the subrogation is expressed by the acts of the creditor and the third person. The latter, as in the case of sureties, where the subrogation is effected or implied by the operation of the law. See also legal subrogation.
See, I'm gonna be honest with you. When you niggas, y'all sit up here and you go, that's what that attorney tell you to do.
Yeah.
Shut the fuck up and let him handle it.
Right.
So the niggas shuts the fuck up and let him handle it. And I just want you to understand how that works. While you shut the fuck up and let them handle it, you guess what you're gonna be regardless. You're gonna be the surety for this case because you're nowhere in that case are you mentioned. They charge official person. So the contract is between the state versus James Murray, which is the artificial person. And they're going to make James Murray do 10 life sentences, right?
Right.
Because this corporate fiction can't pay no bills other than by doing slave labor. Do you get what I'm saying? Substitute your body in as the collateral for this account. But then when you as one of the people kick in and you're like, wait a second, wait, the people could use this privileges and immunities clause of Article 4, Section 2 of the Constitution. I'm going to apply an exemption, which creates what? A credit offsetting the tax liability on the account, paying up the account. So now you're paying for who? James Murray. You're freeing up the prosecutor's liability.
So
now
wait,
you're expressly
catch me for a fall. Now I'm trying to get understanding. So now we're talking about what about the fact, this is what struck me while you were talking. What about the fact that people talk about through the right of subrogation, giving the prosecutor this, like they say, well, where's your checkbook? They shift the tax and that you can stick that prosecutor with some kind of tax liability anyway, but it's being shuffled off onto us. And by you, you got to clear me up there. I don't fall off the wagon that quick.
We're gonna break it down. You remember all the time they say, man, we're forcing the taxpayers to pay for this incarceration. We're paying the taxpayers to pay for this incarceration. The taxpayers are paying for the incarceration because their fellow citizens or their fellow persons, meaning you're failing to exempt the liability on the account. You're
right. You're the only one that can do it.
You're the only one who has the best interest to do it, because they're using your flesh and blood as the collateral for the account, or as the surety, or the subject matter of this account. You're the only one who has the signature. You're the one holding the title. You're the rightful owner of the account. You're the surety. You're the main surety. And we could break this down into the Treasury Department where you're entitled to the goods. We could break it down to you're entitled to the money and stuff. This is why you want to be the surety. Because guess what? You always have. You have the ability to pull out this fucking exemption. Mm-hmm. This exemption is free for everybody. Haven't you ever known somebody who donated something to somebody, to a nonprofit organization, or donated something to a company or something like that?
Right.
So now they could get a write-off because they donated something to somebody.
Mm.
So let's for an example, we're gonna go back to this. You owe $10,000 in taxes. And I say, brother, man, if you donate a TV to my company, I'll give you a $300 tax write-off. So you donate the TV, I'll write on a certificate that you donated. Now it could exempt your tax liability for $300. It's all accountable. So when you go to your CPA or whoever does your taxes, you could also show, well, I got an exemption here. I could get a deduction from my tax liability. In this particular situation, this person here, he's saying, I'm the surety in this case, and I'm going to pay. I'm going to pay with my exemption in the above referenced case. It's under penalty of perjury under the laws of the state of Michigan. Now he's making it abundantly clear how he's doing this stuff. And what does he say here? What he did is he transmitted an obligation to the court administration for full and private settlement. For full and private settlement. Settlement means the settlement here is not saying he's getting rid of the case. He's saying he gave it to them for settlement. And when he said for settlement, well, when it's all said and done, who's supposed to be entitled to the property? Whoever paid for it. And in this particular situation, since he used his exemption to cover the liability on the account, he's entitled to the goods that accrued from this account. Does that make sense? I take it that he's doing something. So he's entitled to the stuff that's on the account. And I'm seeing something down. I saw some words at the bottom. Okay. Look at when he comes back on here, if somebody wants me to go over number 1 again about tendering payment, we'll go over that. But we'll go into number 2. Okay. There's a situation. If somebody could pull up, we're going to go under debt collections and debt under 28 USC section 3007. We're going to go to 3307. We'll start talking about what your rights are. Just a second.
All right, I have it pulled up.
Okay, did anybody have a question to that next one? Okay, we're going to look at 07, and this is we're going to, because this is talking about rights. If you're to go to D, it says rights of good faith transferee or obligee. Okay. Now we're going to look at this. Now, at this section here, because this is when you remember the judge asked you a question. He said, "Do you understand that you're giving rights?" And when rich nigga says yes, were you forced to threaten this? And then you say no. What we're talking about is what your rights are right here. And when you start looking at it, now the problem is if you start talking about what your rights are in this situation, the United States is going to want to avoid contract or that obligation. I was receiving a phone call. The United States is going to want to avoid that obligation because now all of a sudden they're not going to receive the benefits from it. And this is something that they don't want. They want to collect that interest. But look at what the rights are. It says, notwithstanding the voidability of a transfer of obligation under this subchapter, a good faith transferee, which they obligation to you, or the obligee. You're the obligee. You're the one responsible. You're the obligee and surety for this account. And I don't know if any of you guys study law, but when they talk about when they talk about things that are not absolute, they use the word shall, may, and but in this situation, when it's an absolute, they're going to use the term is. It says the good faith transferee or obligee is. We're talking about a right. It's not subject to anything. Because the good faith transferee or obligee, once you're possession of this negotiable instrument that they transferred over to you, and the judge asks you, did you receive a copy of that? And you certified yes in open that you did receive a copy of it. It indicates that the obligation was transferred to you, and now you're the obligee on account of this case. So now the good faith transferee or obligee is entitled to the extent of value given the debtor, which they are the debtor, because what makes them the debtor? Because they have an obligation to do what? Lay and collect taxes. And it says, to the extent that the value of the debtor is entitled to the extent of value given the debtor for the transfer or obligation. Now we're going to understand what your rights are. To a lien on or retain any of the interest in the asset transferred. I'm going to say that again. Since you're the one who has this obligation here, you're the transferee and you're the obligee here, and you transmitted to them your exemption, which creates a credit on their account. Shall be entitled, you are entitled to, you is entitled to a lien on right to retain any interest in the asset transferred. Then somebody says, what asset? What are they talking about? What's the asset? See, I want you to understand what if you're to go to the definition of an asset. I'm not saying go there right now. It's an item that is owned and has value. Here they gave you a title to a nigga. If you registered your ownership or your title to this, now if let's say if it's a Bentley or whatnot, if you registered ownership to your Bentley, this title now is an asset to you. But the average nigga can't see the asset because guess what it's saying? Lock the nigga up. But if you look at it from a slave owner's standpoint, I got 1,000 titles to 1,000 niggas. And at any given moment, I could transfer this title. Now you can start seeing that this is, and the state recognizes my ownership interest in it. So thus, this right here, this title here, is the asset. It's an asset owned by me because I'm the registered owner here, and it's transferred to me. So it's right here. It says, he is entitled to the extent of value given by exempted the liability on the account to a lien on, or I could go put it to somebody else and give it to somebody else, or retain the interest in the asset. What is the interest? The thing that gives the asset of itself, this piece of paper, its value. The thing that you remember, the Bentley in itself is the asset. The title to the Bentley in and of itself is the asset. But the Bentley itself is the interest which is associated with the asset. So now, if on the public record it indicates that I'm the owner of this obligation, they transferred this obligation over to me, I am entitled to retain the asset that they transferred over to me. And what is this? This is my right. It's not subject to interpretation or anything else, because it says the transferee or the obligee is entitled to it. Right? Now, then the second part, it says, what does it say? Okay, we'll bypass the second part. We'll go to the first part. We'll go to the extent of value given, the obligee is entitled to enforcement of the obligation incurred. Now, understanding the obligation incurred. The obligation incurred, since they said that this nigga is a slave. Now they can't say that he can't be a slave because the obligation incurred. So now guess who's it? So I'm entitled to enforce this obligation. If this person here, if this person is to be a slave, guess whose slave he is? He's the slave of, and the person who's a slave to is entitled to enforce the obligation. Does that make sense? Do you understand that? When put it like this, and this is some legal stuff. In understanding the legal aspect of this. Okay, because I need to hear somebody talk real fast.
I hear you.
Okay.
Yeah, we're here. When you're saying the slave, are you referring to your straw man being your slave if you know how to handle it or run it?
The fulfillment of an obligation. The science behind the fulfillment of an obligation, right? Let's say that you yourself personally, you draw up a negotiable, you draw up a promissory note. Okay.
Right.
First name?
Reginald.
Okay.
Reginald.
It says on the obligation, which is a contract, the promissory note is a contract. And the promissory note is you're the promisor. Is now the contract is going to talk about the promisor, what the obligation of the promisor is repeatedly, right? And subsequently, the name on the contract is Reginald. Since Reginald is the name on the contract as the promisor, the contract isn't between Reginald; it's between the contract is with the promisor, which subsequently is Reginald. So through the contract, they're going to talk about the promisor, and in this particular situation is Reginald, right? So what happens is, he gave me the promissory note for whatever reason. I gave you $10, or I gave you a TV or whatnot. So now it shows that the promisor has to pay $50 a month for 10 years, right? On this promissory note that you signed, right? Well, all of a sudden I go get $500 from somebody, and I kind of like want to get rid of this note because I don't need it no more. And somebody offered me $500 for this note that's probably worth $10 or whatnot, and I go give it to them, and they go give me $500. Now, since you made the note, you're the promisor on the note. Guess what happened? So now this person over here is able to enforce the obligation against the promisor subsequently, which is you, because they are the holder of the obligation, the promissory note. You see how that worked? So I'm gonna tell you.
I see what you're saying.
Say that again.
I see what you're saying.
Okay,
Go ahead.
so I'm gonna say, Reginald, you no longer pay me. You pay such and such over there. You pay James, right? So and you now think about it. Sometime now since you wrote this promissory note, you got to fulfill your obligation. Since you have to fulfill the obligation. And so when James gets a hold of, he's going to enforce, because it was transferred over to him. He can enforce the obligation incurred, which included whatever services that you had, right? And so you go to James, and all of a sudden, and James, you say, James, can I give you $500? And James says, no. You say, James, can I give you $600 for that? And James says, sure. Right? Now, who's holding the obligation now?
Whoever James is, whoever this other person is, yeah.
I'm going to talk about you, though.
Right.
You gave James $dollars for this obligation. That you. So now who's holding the obligation?
I couldn't hear you. You kind of get out. If you're saying that I now purchase the obligation from the other individual, if I purchase that obligation, then I would be the holder. Go ahead.
Right.
Holder, of course, of the obligation. Yes.
Right. So now, though you wrote the obligation, but now that you're the holder of the obligation, you could enforce your payment of the obligation to the holder of the obligation, subsequently yourself.
Okay.
But in all aspect, that sounds crazy, but legally, you could enforce the obligation against yourself because the obligation is still in existence.
Okay.
Do you see how that worked?
Yeah, I see what you're saying.
So when the obligation, it says that this particular individual is going to be a slave. If you the obligation,
Okay.
now you can enforce the obligation against the slave.
Right. Which
If
is the
it's
straw,
you.
which in this particular case is the straw.
No, the straw man is the person on the obligation, but you're the actual collateral or the property asset in the obligation. Does that make sense?
Okay, so you're saying you're in reference to the live living being as being the so-called slave in your representation, if I'm seeing this correctly, the person that has the authority to enforce the obligation. Is that
Yes. See, because who actually wrote the obligation? The obligation said we're going to keep this individual incarcerated, and we have to pay interest on this obligation at 6% annum. So that those are all encompassed in the obligation that the state created. Okay, so now what you're doing, you're saying I want to retain the interest in the asset at my house. You understand that? What's the interest or the asset? That's the property, the physical human being. Enforce the obligation of the state to pay out the interest.
okay?
Because that obligation that they created, since they created the note and you're holding it,
Right.
you're entitled to enforce the obligation incurred. You're able to retain the interest in the asset, meaning the property, the actual physical human being. You're entitled to collect it, enforce the obligation, the interest that they pay on the obligation. The interest, that's 6% per annum. And you have another right here. It says, or a reduction in the amount of liability on the judgment. You could get rid of the liability. See, because if you're the surety in this matter, which you are the surety, you have all of the rights to dictate what goes on. Do you understand? Do you understand how they work that? It says you have a right to, you can get this property released to you. You have a right to collect that interest, or you can reduce the liability on the judgment because you have the rights. The judge asks you the question, do you understand that you're giving up your rights, you dumbass snicker? He's really indicating these are your rights because it states the rights of the good faith transferee and obligee. So now guess what you should do now? You should stand on your rights now instead of having that attorney conning you into some bull crap. So when it says here, I'm entitled to enforce the obligation of the state of Michigan incurred. This is number 2. He's stating this to the courts. Now you ask what individual actually go tells a court? What individual actually go tells a court, hey, I'm entitled to enforce the obligation of the state of their state incurred? People don't do that. People don't have the mental capacity to do that. Okay, does that make sense?
Yes. Go ahead.
You have the right to enforce the obligation and how you want it to be done. And the next one, it says, I do not waive any of my rights. You're letting them know I'm not waiving any of my rights, including and not limited to human rights, right to bear arms and right to bear arms, because they gave him a gun charge. They gave him a gun charge. The gun charge, they're pretty much charging with nigga with gun. So he says, I'm not giving up any of my rights. And the Constitution protects his rights more than the right to lock a nigga up for a gun, because the Constitution specifically says that the right of the people to keep and bear arms shall not be infringed.
Right.
So now, so understand it. So see, a nigga that don't speak can't say this.
Right.
So the whole court case is going to go forward if you don't say any of this. So what does the fourth one say? I invoke protect self-incrimination. You have a Fifth Amendment right not to yourself. So the whole time when you have an attorney, guess what he's telling you to do? He tells you to plead not guilty to create the controversy. Then he flips it and he tells you, well, just plead guilty. Once you plead guilty, you're incriminating yourself. But the Fifth Amendment says, wait a second, I invoke protection from self-incrimination. I'm not gonna go in this court and tell you that I had a gun. I'm not gonna go tell you that I robbed the bank. We don't have to have that discussion. A matter of fact, we're gonna settle this case out of court because you guys proven that I did it, but who cares? So your protection against self-incrimination. And what's the fifth one say? I am not the defendant. I am a human being distinguished from the person charged. They never charge you, they charge that person. How can they make McDonald's go to jail for something that Burger King did? But McDonald's paid a bill. By right of subrogation, he's entitled to McDonald's goods because he did pay. He's not denying payment. He used exemption to offset the liability on it. And now in this situation, in the last it says, and 6, this court lacks subject matter jurisdiction. The subject matter jurisdiction in this case includes the jurisdiction to pronounce judgment against the property of the defendant. Well, once the property is exempt, majority of ownership interest in the defendant is with a private entity, and subsequently, in this case, Murray James Earl. The court lacks jurisdiction in the matter of public property. It's owned privately, Murray James Earl, which he indicated that he registered ownership when he paid it this is why he says, see attached copy. It says this court lacks subject matter jurisdiction. Do you understand? And when you go into the paperwork, you're going to see how that works. And it says, what does it say? And in the last section, it says, accordingly, in the interest of justice, I demand that this court release the order of the court to me with interest as provided for on account of this case at the address above. The reason why he's saying this is like, I'm not going to get rid of this case. I'm saying release the interest, the subject matter of this case. Release the subject matter of this case to me, that nigga, and the interest that accrued from this account. Release it to me. So then, what does he say? So now, on this statement here, on the beginning statement of the statement here, he said here, I tender payment to the court administration for full and private settlement. He's going to, on this page, he sent a copy of his transmittance to the administrative office of the courts. Prior to him giving this letter to the judge, he sent payment with the letter to the court administration. And what he said in the letter on page, I think this is page, it says, because this is court administration, he said, deposit such security enclosed into the public registry as payment for full and private settlement. And he's telling the court administration, to the extent there's an amount owing, direct payment to me. Once the court administration, they deposit this into the registry, and they see that this is the security there on the record. And and since he's signing off on it, it's going to say, to the extent there's an amount owing direct payment to this corporate entity that controls, not the BOP, not the DOC. He controls it. And he said right here, if you have any questions, comments, or concern, direct the same to the undersigned at the mailing address above. Then he said, thank you in advance for your attention to this matter. Because we're not going in here arguing. The courts actually work for you. So say your attention. So then you go to page 4, see the charging instrument that was transmitted to the court.
This is a quick question before you move on.
Okay.
What if someone like took a plea and all of that, and it's within the 5 years? How would they reword the letter and to requesting that interest and that is owed to them, or would it just be lost?
Okay, we went over a statute that we went over a statute dealing with the withdrawal of money. We went over statute 2042 of money. It says, and what is it? Okay, hold on a second. I'm gonna go here. Just a second. I'll pull up a law here. Elaborate on this. Just a second. It's tricky, and here a problem that you're going to find with this is that human beings aren't used to what you're doing. I want you to when I say that, it's because particular situation, since they're not used to somebody saying, hey, I want my money. If you're to go to 28 USC section 1963, 28 USC section 1963. It says a judgment in the action for the recovery of money or property entered in any court of appeals, the district court, the bankruptcy court, or any court of international trade may be registered by filing a certified copy of a judgment in any other to a court of international trade or any judicial district when the judgment has become final by appeal or expiration of time for appeal or that entered the cause is shown. Such a judgment in favor of the states may be so anytime after the judgment is entered. A judgment so registered shall have the same effect as the judgment of the district where registered and may be enforced in like manner. A certified satisfaction of judgment in whole or in part may be registered in like manner in any district in which the judgment is a lien. And I want to break the science down so that you can understand this right here. We're going to go back to the concept in acceptance that slavery is it's an acceptable thing. It's an acceptable thing, and it's not wrong. It's wrong because it's just strictly business. So now, if they took your slave or your alligator, right, and they certified it and they gave you on the record where your alligator is being held at, in order for you to alligator out, what do you have to do? It says in an action for the recovery of your money or property, that alligator or that slave, and then enter in any court. You have to go file it. You have to register that so they can find out where the property is. Then when you put words like this property is exempt, so now a court could issue a court order to have that property released. Because if you were to go back to 2042, it says no money. See, because no money, because now when on 1963 that we just read, that's to get the property release. But now if you want to get that money that was deposited under here, in every case in which the right to withdraw the money in the court under this section has been adjudicated and is not in dispute, money, and such money has been deposited at least for 5 years unclaimed by the person entitled thereto. Such court shall cause such money to be deposited in the treasurer in the name of the United States. Now, this next sentence, it says, any claimant entitled to such money may, on petition to the court and upon notice to the United States attorney and full proof of rights thereto, obtain an order directing payment to him. Did you understand that?
I did, thank you.
Because and we'll look at these words, because you got to be very particular, because these people are not trying to unask that. It's payment entitled to. You remember what? We'll go back to entitled. You remember we mentioned of the debt where you right the good faith obligee. Now you're going to find your rights. With your rights, there are entitlements. Entitled to any such money, the interest on the account of that obligation. Because now you can prove that any claimant entitled to any such money may petition the court and upon notice to the United States attorney with full proof. Full proof is a legal term. It's dealing with on public record. Or once you register ownership of it with the court clerk or whatnot, and now it's on public record that, hey, I such and such, I accepted this. Now, and you got to give notice to the United States attorney with full proof of rights thereto, may obtain an order directing payment to him. So now you could demand payment, and this may take another court proceeding. And understand what they said is whether the case is pending. This is because the United States is still holding the money, and they're holding your money, and they're going to claim your money. They're claiming your money because no one else is. They're praying to God that you, as ignorant as you are, you never claim that you claim the money that's owed to you. But if you use the law like they're sitting up here, then you could get that money. Does that make sense?
It does. Thank you for explaining that.
And now understand this. This isn't absolute forever, because it's not absolutely forever. You have like 10 to 20 years the particular obligation, and that's, you can find that out in criminal procedure if how long they have to pay. But understanding how they work the interest is based upon it's a basic principles of how much is the statutory provision for the actual offense. If the statutory if the statutory charge is $5,000, it's at 6%. 6% of that is $30,000 a year. So, and you could stand on it because it's like, this is the obligation that you guys wrote. It's a felony. I'm entitled to collect the interest on this. Now, will you sit up here and go to court doing that? You might need an attorney to do it. Now, can you find an attorney to actually go against the confusion? Do you understand the science behind that?
I do.
You go get in. See, because the attorneys, they're all in cahoots with trafficking. So now here you come in talking about you might have to be strong, because getting somebody else to do it, getting an attorney would do as an officer of the court who's never done this. What they've been practicing is to trap and trade you and your brother, your cousin, anybody else.
Right. I'm a paralegal. I pretty much understand. It's just I appreciate you breaking it down for me. So.
Okay. See, and what's funny is because especially you being what you attorneys, you probably came in there with dealing with attorneys, and they have the same process over and over again. How they shuffle people through the system, they offer them and after they enter that judgment, and then the courts start kicking out the money to the they kick out the money to the attorneys after the property is sold. Isn't that correct?
Correct.
They start getting paid off. They get their attorney lien money. They start accumulating the interest from that obligation, when the money is really rightfully belonging to the person who's doing the time, the sure account.
Right. This makes complete sense. I appreciate it. Yeah, I've worked in criminal law, so this really makes sense. It's all about getting the best coat to wear.
I'm being honest. When I was in prison, all I did was I why is this happening to me? So guess what I did? I studied them. I studied them I studied them nonstop. I studied them. I'll show you. They're not hiding this stuff in this criminal law stuff. Wait a second. I'll go 28 USC section 28 USC section 2464. It's one over from what we just went over. Break this down. This is the slave trade that they're doing, and I'm not saying it's a bad thing, because if you say it's a bad thing, then you'll want to shy away from it. But when you start looking at it as a good thing, then you'll start understanding. Wait, I want this property here. 28 USC section 2460. We're going to show you a little secret that they're pushing off. And this is dealing with the fines and penalties. You're not in prison because of the offense. You're in prison because of the fine or penalty. You're in prison because of the penalty. I'm telling you stuff because this stuff is talking about people going away that money and all of this other stuff. You see it, except as in case for seizure, forfeiture on laws of any laws of the United States, or of arrest, or other process in realm is issued in any admiralty case. The United States Marshal shall stay the execution of such process. We're talking about now. We're not talking about losing now. We're talking about winning, because we're not talking about losing. We're talking about winning when there's no controversy. I committed or not, but when it said when a warrant of arrest in realm is issued in morality case, the United States Marshal shall stay the execution of such process and discharge the property arrested. And this is where people get confused, because guess what? People aren't understanding that a nigga in jail is considered a piece of property. He's a slave. But now when you start saying arrested, discharge the property arrested, if the process has been levied on receiving from the respondent or the claimant, meaning the human being, or who's the person who's responsible to handle this case, meaning you, receive from the respondent or claimant of the property. On one hand, you're the respondent or the claimant, a human being, but on the other, because you're one of the people, then on the other hand, they're treating you as the property, because, right? It says the respondent or the claimant of the property, a bond or stipulation double in amount claimed by the libelant. The libelant is them who's sitting up here saying, look, you're a piece of shit. They said that the defendant is a piece of shit. They're defamating your character, which is a libel. They're saying that he's a piece of shit. So now what you do is you give them a bond. You take that same obligation that they gave you, and you're promising here, this will cover your payment to settle the case. And when you say settle the case, it's however much amount that you got is owed, this is the amount necessary to settle it. So therefore, it covers the whole concept of double the amount claimed by the libelant. It says, with sufficient surety, who's the surety? You, to be approved by the judge of the district court where the case is pending, or in its absence by the collector of the port. Who is the collector of the port? The court clerk. Conditioned to answer the decree of the court in such case. So if the judgment of the court is, when the judgment is always said and done, the judgment is going to say, we're going to tax the nigga. We're going to make him pay. He has to pay. But now this is going to satisfy that by using which creates a credit, offsetting the tax liability on there. So no matter what judgment they enter against it, your exemption.
You muted, Tommy.
You accidentally muted.
We can't hear you, brother.
How long was I muted?
For about a couple seconds.
We're to discharge the property arrested and receiving from the respondent or claimant of the property a bond or stipulation and double the amount claimed by the libelant, the one who's telling you, with good and sufficient surety. Aren't you sufficient surety to cover the debt?
You said that.
Yep. Yep.
Because you're the surety that's gonna pay the bill anyways. So
That's
you're
right.
good.
So, Charlie? Yeah. That's serious?
100.
Somebody's not on mute.
Oh, you did,
Somebody's
right?
not on.
Lord, oh,
Okay, good, sufficient surety to be a judge of the district court where the case is pending. See, if you're good and sufficient surety to do all that time for the defendant, you're good and sufficient surety to use your exemption to defray the liability assessed on the account. So the judge would say that if you'd have brought that up to him. Such bond or stipulation shall be returned to the court because they created the bond, and you're stipulating that you're going to use an exemption. Such bond or stipulation shall be returned, and the judgment and decree thereon should be against both the principals and the surety. They're the in this case, and you're the surety in this case. With the principals and sureties and all the actors and participants in this case, now all the liabilities can be settled based upon the fact that you used an exemption. Hold on a second. What does it say? And may be secured at the time of rendering in the first case. Now it says the owner of any vessel may deliver to the marshal a bond or stipulation with sufficient surety to be approved by the judge of the district court. Can the decree of the court in all or any cases that are brought thereafter in such court vessel. Does anybody understand what that means? Any question on that?
Okay, so what is the vessel? Tell us, what is the vessel?
The vessel is jury. Is the vessel to transmit a piece of property through admiralty in a maritime jurisdiction.
Right.
It's the name of the ship that they're using to transmit the goods. It's the name on the manifest. That's the name of the vessel. So, but here are you a registered owner?
Yes.
Well, I'm not talking about you personally, but the average person.
No.
The average person, they never registered ownership in the manifest as being the owner of the vessel.
True.
So by registration with the court clerk where the case is pending or adjudicated, the owner of any vessel may deliver to the marshal a bond or stipulation with sufficient surety using your exemption to defray the liability on the account with sufficient surety to be approved by the judge of the district court in addition to answer the decree of the court in any and all cases brought in such the vessel. So in any situation, if they brought your person back in here, it could always relate back to the initial tender of your exemption. Your exemption is unlimited. Because if you're smart enough to actually exempt the liability, you could use it in each case. And you could explain to them over and over in each case that I'm going to use an exemption. I'm exempt from your jurisdiction. I'm immune. You guys don't have to take this one in. You could claim my exemption to defray the liability on the account. What does it say here? It says, thereupon the execution of such process against such vessel, your person, shall be stayed, so long as the amount secured by the bond or stipulation is at least double the aggregate amount claimed by the libelant in such suits which done and pending in such against such vessel. See, they don't charge you, they charge the vessel. But if you use if you use your exemption to defray the liability, they could release the defendant. And it made it clear that they could stay. What did they say? Thereupon the execution of such process against the person shall, as the amount secured by the bond or stipulation is at least double the aggregate claimed by the libelant. So if they bring another charging instrument in there, you put up another bond, which will cover the liability again. It says similar judgments or decrees and remedies may be had on such bond or stipulation as special bond or stipulation have been filed in each of such suits. Does anybody have a question on that?
Yes, I do.
Okay.
Is the bond, the exemption, that James Murray wrote on the charging instrument, is that considered a bond?
I'm going to give you the. We're going to. There's like over like 50 definitions of bonds in Black's Law Dictionary. We're going to go look for the most simplest one because it encompasses everything. Okay, I'm gonna go to the first one. The first definition of bond is very simple. It says an obligation, or colon, a promise. It's a bond. If I tell you, hey, if you give me $5, I'll wash your car, and I write it on a piece of paper, is it an obligation?
Yes.
Is it a promise? It's as simple as that. But, right, those are obligations. Well, once they go register this registered that we trap and traded an individual. We trap and traded him. And then if the bill on this obligation is satisfied, or if this bill is claimed, we have to release. So did they give you a bond? They gave you the bond. And once they gave you the bond, if you give it back, did you give them a bond?
Yeah.
You gave them a bond of equal value. Your exemption on there, which creates the credit on there. So if you don't have a bond of your own, like here, you could write your own bond on a piece of paper. Here, you could claim my exemption to offset the liability on account of this case. Put the case number on there, and you turned it into the court system. Now they have a bond. But what if you don't have a bond such as that in your? If you don't have a $100 bill cover the $100 that they said that you owe, simply give them their bill back. And don't call it giving them their bill back. You're saying that you're tendering to them an obligation or a bond. Does that make sense? You don't say I'm giving you your bill back, because the law doesn't say give them their bill back. It says to receive a bond. So you simply give them a bond. And then if they say this is not a bond, then why am I in jail? You bound me over with this. It's on the books. It's the obligation. It's a bond. Does that answer your question?
It does. Now, can you create your own blanket bond and file it into the court, the Register of Deeds in your county, and let that indemnify you for all future charges from anybody?
No, and yes. No, that doesn't make sense. And I'm gonna be honest with you. It doesn't make sense. We all want to do that because we want to be left the fuck alone. I'm just being honest with you. Just leave me the fuck alone, right? But that doesn't make sense. And the reality is, we have to look at what your person is. Your person was not created by you. He was created by the state so that you could do commerce, to do commercial activities. He's a consul. His job is to do business with you. I mean, to do business for you in different transactions. Like when you go get your insurance, your person's going to be on your insurance card. So your insurance company, because of the contract that you signed with your insurance company has a right to make claims against that person. When you acquire a driver's license, the state you're going to want to contract with your person. So each time an entity or person has interaction with your person, you're going to contract with him. But each time, guess who's responsible for that account? You are. Each time, do you get what I'm saying? You can't just be left the hell alone and not. If you're gonna go into the mountains or whatnot and never deal with nobody, sure, you could do that. But the reality is that you're going to interact with people, and each time to interact with somebody, they're going to make a claim against who is property of the state, which is public property, and you have the ownership in that public property's property. And I wish you could understand that you have an interest in the riz or the subject matter of that person. Let me make this clear, and I hope you can understand. When you're born, they created a corporation. So you have to understand that it is in fact a corporation. And one thing corporations corporations have multiple owners. We'll say that it has 100 shares in this particular situation. So your corporation has 100 shares, right? Well, in any particular situation, a person could make a claim or ownership interest in your corporation. Like if your corporation, if I fix your corporation's cars and I charge, so now I'm gonna register ownership of your car for $50. Now the majority of ownership may be held by you because you have $10,000 of ownership interest in your corporation's name. I have an interest in there and I could demand payment. And this might sound crazy. It might be your organization, but I have an ownership interest in your organization, right? So when I send you a bill for $50 because I have an ownership interest in your bill, in your corporation, then in that situation, I'm in essence saying I will release my ownership interest in your corporation, much $50. Then you'll own 100% of ownership in your corporation because you paid the bill. Does that make sense?
Yeah.
Okay. So now, when you say, can I file something on the record that keep them from to leave me alone? No. Here, if you smack the shit out of somebody, if you go smack the shit out of somebody, the police are going to pull you over, and your paperwork's not going to say you can't pull me over because there's a reason why they did it, and it's a justifiable reason. But now, do you have to go to prison behind it? No, because now you'll use an exemption to defray the liability on the account, then they release you. When you're speeding, he has justifiable reason on pulling you over. Then what do? You use an exemption to defray the liability. Does that make sense?
Yes, it does.
Yeah.
Thanks.
So the concept of you just being left alone and them never not doing nothing to you, that doesn't theoretically make sense because you're going to still use your person to do business. You use him to do business because that's what he's designed for. What name would you like? And then you're going to put it in his name. So now you open him up to do business. Then when they say this account is beneath the minimum balance and they're going to charge penalties, it's your duty or your responsibility to put his account back up to par. Because his design is to incur liabilities and costs and to transfer. Does that make sense?
Yes, but I'll tell you where this question came from. I've heard,
Okay.
People obtaining status of do not stop, do not detain. And that's why I asked the question, did they put something on the record somewhere that prevented them from being able to be accosted?
Okay. Now we're going to, I think it's Title 22 of the United States Code talking about foreign affairs. When you're able to ask concept that the United States is it's Washington D.C. and these state facilities, they do is they incorporate inside the United States and they become citizens or partners with the United States. But I don't know what state you're in, but each state in and of itself, the actual territorial land in which you live in is foreign to the United States. It's actually foreign to the United States. So it's kind of funny how this works. But so once you're able to understand that you're foreign to the United States, how we live in America, right? But then the United States is Washington D.C. But since the United States does business in America, what they do is by constitutional grant, we gave them authority to have jurisdiction in the federal buildings, and that there becomes the United States of America, they're going to impose the laws of the United States in that particular consulate. I'm going to call it a consulate or that enclave of the United States in that office. And what they do is they come in America, the United States, they come in America, and what they do is they come in America, they scout over America, and they trap somebody or they trade somebody, and they bring them to the courthouse of the United States, and apply the laws that apply to America when they're doing their business in America or your state. Does that make sense?
Yes.
But they're gonna apply the laws of the United States. So but the laws of the United States actually says that America has all the rights. So and when you start understanding, and when you say use my exemption, you're indicating that, well, you caught me doing an offense in America, though you're going to charge me with United States. So now you could claim the exemption because you're an American. So now, and with that being the case, a lot of times what people fail to understand is, well, you're one of the American people. And if you, and in each, I hear about the Moorish Science Temple or the Moors, they use their Jamaica, other these countries, they fly their flag. By them flying their flag, that they're not a part of the United States, and therefore they have diplomatic immunity. But the American people, we fail to fly our flag. And if you fly your flag and you understand and operate the laws, there's enough laws that say that the American people are exempt from the jurisdiction of the United States. And each time you go into a court, whether it's a state court or the federal court, they're all operating under the laws of the United States, because the state courts have incorporated in the United States and they're imposing the laws of the state. But does that make sense?
Yes.
So that's how they fall underneath special marine jurisdiction, and that's how they get to use needful buildings, right?
Yes, yeah. That's definitely, what is that? That's the enumeration of powers. The enumeration of powers, the last section of the enumeration of powers.
Yeah.
It's the last section. I think it's the last section. Hold on a second. Of the enumeration of powers. And so they're imposing the laws of the United States on all, because the American people really want the United States to trap and trade niggas and keep them out of their hair. And I'm trying to make that clear without seeming too negative. It says here, it's the second to the last clause. It says, to exercise exclusive legislation in all cases whatsoever over such district not exceeding 10 square miles at by session of a particular state, and the chapters of Congress become the seat of the government of the United States, and to exercise over all places purchased by the consent of the legislator of the state, in which to be for the erection of forts, magazines, arsenals, dockyards, and other needful buildings. Right. So the people, since we want them to trap and trade slaves for our benefit, our protection, right? So then that's a needful. So they acquire these needful buildings and stuff so they can impose the laws of the United States. And this is, the state has to authorize this.
Right. I think in the states in the titles, right, for the state, somewhere in there says state, and it's going to show you exactly in every state where they have that section in there, lands and whatever needful building that the United States needs. It's in their laws also. And
most definitely.
Yeah, and I think they're using the state's laws, right? When they said you like jurisdiction, they're using the state's laws in the United States.
Okay.
Concurrent jurisdiction. Concurrent laws.
The stuff I can't say that it's simple, but it makes perfect sense. Let's say that you start or we'll call it McDonald's. I don't know what state you're from. Let's say that you're from and you
New Jersey. I'm in New Jersey.
Good. Okay. You created your corporation and called McDonald's, right? Yeah. And you created it under the laws of New Jersey, and people love your restaurant or whatnot because it's a restaurant. But then all of a sudden you hear that California is a thriving place where you want to start a business, right? So then all of a sudden you want to start a business in California because you hear it's thriving. But the laws of New Jersey may be different than the laws of California, because the laws of California are different, and so you have to critique your establishment or your McDonald's to become McDonald's of California. which is now subject to not so much New Jersey laws, but laws of McDonald's, because the laws of California, because the laws of McDonald is the laws of McDonald. The laws of California is the authority in the land called California. The state of California there's a corporation in California called California, which the people have elected to be the number one corporation there. And the corporation there is the state of California said, well, we'll create your McDonald's of California. I mean, your McDonald's will be McDonald's of California, but it's subject to the laws of the state of California.
Mm-hmm.
Does that make sense?
Yeah.
So now when we look at United States, where's the United States? It's the District of Columbia, Washington, D.C. Congress has the authority to make all the law United States. But when they inside of one of these American states, now it becomes United States of belonging to America. Who has the authority and jurisdiction in America? We, the American. Yes. This is why you fly your flag and be like, nah, bitch, no, I'm gonna use this exemption here, and then you're gonna use the exemption. We know your job is to levy taxes, but what we're gonna do is we're gonna use an exemption here, the privileges and immunities. Now you're telling them to stand down and perhaps stand back. You know, the problem was, I don't like Trump, but the whole concept is now you're telling them to stand down and stand back, because it's like, do you see this flag here? It's a flag. You guys owe your obligation to us. And I'm suggesting that all you guys study your Constitution, and you're going to start realizing it says, I have the power. I have the power. We could change government. I don't know if you guys ever read the Declaration of Independence, but it really clearly tells you that you have the power to change government. And it indicates that, look, the government is going to do some scandalous shit by this, supposed to do something for the protection of people. If you have an evil entity that's doing wrong in your neighborhood, you want the biggest, baddest, evil person to be able to wipe them out. And this is why we have the government, which is completely very evil, because it has to deal with a lot of different evil people on different levels. But intelligent people, smart people that understand this science, they know how to maneuver around it. And that's where it be. Does that make sense? You just have to.
Make a lot of sense.
Yeah.
You have to make yourself wise enough to understand how this system works. And when you understand it, and there's so many laws. I'm short on time right now, but there's so many that could go over this stuff, and you could break it down. And once you're able to use the law, because you guys are law enforcement officers, the law enforcement officers, by you using the law against them, they have to accept it. Does that make sense? Have you guys ever read that? You have a right to retain any of the interest in the asset transferred. Have you ever thought about that this obligation that they gave you is a? Have you ever looked at it from a thing? Black people, our people were so prone to saying slavery so bad and so wrong and stuff. It wasn't wrong to the slave owners. It wasn't wrong to them. And you can't. So guess what you should study? Instead of trying to get rid of slavery, because they said that we're never going to get rid of slavery. So what you need to do is learn how to own property. And when it comes to tax liability, say that you have to pay taxes, you need to learn how to exempt the tax liability and demand what's rightfully yours. The interest that accrues from their obligation, it belongs to the American people, and they can't hide it. They just know that you're not smart enough to claim it. So what happens? They collect it from the taxpayers, the treasury, and they pay the interest on these obligations. And they subsequently, if you never, 10 to 20 years down the line, it goes back to 401ks, their IRA plans, and other. Then they get the benefits that come along with their offices or departments within inside the United States or the state government.
Before you go, I know you said you're short on time. The next page, the stamped and written on that charging instrument is obscured by the black print of the charging instrument underneath it. And so I would need for you or somebody to read what was put on there for the exemption so that I can make sure that I put it word for word on mine.
Okay, I want to make this abundantly clear so that we have a clear picture of how this, and this is what should be on here. But understanding the concept, you have to follow in this particular situation, you have to follow the protocol. First thing he did was they gave him the obligation. They was like, look, this nigga ain't never gonna figure this out. We're gonna get him with nigga with gum. They gave him the charging instrument. They brought him before the court. The court said, receive a copy of it. And he said, yes. Okay. Since he got a copy of that, he is in possession of the charging instrument. Then they said, well, how do you plead? Or well, they didn't arraign him just then. Since they did not arraign him at that time. So they set a bail bond. They bonded him out. So now he has in his possession a copy of the obligation, right? Okay, so now they released him in this particular matter. Since they released him, he has in his possession a copy of the negotiable instrument, the negotiable document which bonds him to this obligation, right? So then when he starts understanding that, wait a second, this is a title to a nigga and a title to collect interest, right? So, and when you understand the whole concept of payment, now it's like, wait, if I turn this, consider it like a check or a claim check. Your check is when you turn a claim check in, you're getting what was checked in. It's not only a what is it? It's not only a lottery ticket, it's a claim check. So in this particular situation, it's like, wait, I want the stuff that's here. I'm going to go register it. And I'm saying I want this shit released. So then what he did is he turned it in. He and understand what payment is. When he turned it in, he transmitted to them in the fulfillment of this obligation is to turn it back in so the property released. And by doing so, it says payable to court administration. Because guess what happens? They're going to transmit this. It says payable to court administration. And it says state court administrative office. And then you put the address on it. That's who it's payable to, right? Because he transmitted it to him and he's turning it in as payment, right? He's turning it in as payment. And then the next line, it says exempt from levy. Exempt from levy indicates that a human being who has the right to exempt the liability, he used his exemption to defray the tax liability on the account. No, and I just want you guys, if you guys should check what the definition, Black's Law Dictionary of the definition of the word tax, it encompasses all monetary imposition, not only monetary, any imposition charged by the government on the person's property and enjoyment of the people to public revenue. So when if they charge you with such and such or this or that, child support or anything, those are all considered taxes, and it's all under the taxing authority. So now when one of the people come in here, he says exempt from levy. Then he indicated on the thing, he said Earl Murray. He indicated James Earl Murray is the human being, because he's a capital or lowercase like a human being would, accepted this obligation for value. Then he says James Murray, then underneath that it says except for value. By him saying he accepted it for value, he indicated which human being is entitled to collect the interest on that account. Then he put his signature on there. He put his signature on there because only human beings signatures. Then he dated when he did it because the obligation isn't past due. He's accepted it. He said, this obligation is a good thing. I accepted this obligation for value. It's mine. I like this. You guys certified that a nigga had gun. Well, I'm entitled to the interest from this account because now he's entitled to enforce it. He dated it. It wasn't past due. Then he put his exemption ID number on there. Now, if somebody could go to the law, there's 1 USC section 9303(4). I'm going to go to that real fast. 1 USC's. We're not skirting this stuff. We're sitting up here looking at it. We're agreeing with it. The law is their obligations are good. As long as their obligations are good, you're entitled to collect money. if you're to go to C, the obligation is not past due. And you could break down these sections. In these sections, they talk about in these sections here that this is in here. This is dealing with the Treasury Department, and they're going to tell you because in this particular section, it's going to tell you something. And if you're to go to C, the use of an eligible obligation instead of a surety bond, like a plea agreement is a surety bond because you, as the surety, you're going to be bound to pay the obligation. Okay, so you could pay by washing cars. You could pay by washing cars to pay the debt to society, or you could use your exemption. It says the use of an eligible obligation instead of a surety bond for security is the same as using personal or surety bond, a certified check,
I have up
a
here
bank draft,
31 USC.
post office money order, or cash. I'm going to read this again. The use of an eligible obligation instead of a surety bond, instead of a plea agreement. So you could give them, instead of giving them a plea to cover the liability on the account, what you're going to use is an eligible obligation, which is the obligation that they gave you. You're going to use that instead of a surety bond for security. And it's the same as using a personal or corporate surety bond. It's the same as a check. It's the same as a bank draft, a post office money order, or cash.
Islam. What's that USC again? I got 31 USC 9304.
303.
03. Okay, got it. Got it. There we go.
9303C. And in his particular section, what did he say in this particular section? And he said 94. Hold a second.
A post office money order or cash. That's what it's saying. Using eligible obligation instead of a surety bond for surety is the same as number 4, a post office money order.
So that's the obligation that they gave you.
Yeah,
personal or corporate surety bond.
Yes. Damn right, it's the obligation. Here, okay, go to 18 USC section 8.
Obligations or other securities of the United States.
Speak on it since you already know it. Read it. Read it.
Hold on, I don't have it. I just know it off the top of my head.
Oh, okay.
The term obligation or other security of the United States includes all bonds, certificates of national bank currency, Federal Reserve notes, coupons, United States notes, Treasury notes, gold certificates, silver certificates, fractional notes, certificates of deposits, bills, checks, or drafts for money drawn on by or upon authorized officers of the United States, stamps and other representatives of value of whatever denomination issued under any act of Congress and cancelled.
Okay, now, in this situation, we're talking about these are nations and securities of the United States under this concept of other securities of the United States. The United States is obligated to collect taxes for the taxpayers, right? Okay, they have an obligation, but so they could create their own securities. The United States in itself could create their own securities, but when they collect taxes for other entities like the Federal Reserve Bank, that becomes the obligation. I want you to understand that. The United States itself could create its own securities, but then this is why they put the obligations. They have an obligation to collect for the Federal Reserve Bank, which is a private-owned entity, who creates their own notes and their coupons. So then they go on to say the United States notes, the United States, Treasury bonds, gold certificates, silver certificates. Then they make it abundantly clear on any act of Congress, as I say, or drafts for money drawn by or under authority of officers of the United States. Okay, so in this section, they're talking about what the United States securities are and what their obligations are, right? And in this particular section, they're talking about the United States and their obligations. Now, could you go to 18 USC section what is it? 513.
So, but isn't there the officers of the United States that issue the order? So you're returning the obligation.
No,
Was there?
if you catch a federal charge, that's off of the United States. This is why I'm taking you to 513. I think it's 513. It might be off one. Hold on a second. Just a second.
State and private entities,
Say that again.
securities of the state and private entities, 18
Yes.
USC 513.
Could you
On the screen.
could you start to read that? There's a lot there, so you don't have to sit up here and dig off into it. But you could start understanding where the states and private entities, how they kick in.
Whoever makes articles possesses a counterfeit.
Stop.
Okay.
We're going to a definition there of securities, because now it's under fraud, but in this particular section, they're going to denote what a security is. And instead of, do you understand what I'm saying? Because we're going to go down to number 3, the term security. And because this is for securities of the state and private entities, we just went to the securities of the state of the United States, not the United States, but deal with the security of the states and private entities. So then you go number 3, what securities are. Definition?
The term security means a note, a stock certificate, treasury stock certificate, bond, treasury bond, debenture, certificate of deposit, interest coupon, bill, check, draft, warrant, debit instrument as defined in section 91C of the Electronic Funds Transfer Act, money order, traveler's check, letter of credit, warehouse receipt, negotiable bill of lading, evidence of indebtedness, certificate of interest in or participation in any profit sharing agreement, collateral trust certificate, pre-realization certificate or subscription, transferable share, investment contract, voting trust certificate, or certificate of interest in or intangible property. B, an instrument evidencing ownership of goods, wares, or merchandise, or any written instrument commonly known as a security, a certificate of interest in, certificate of participation. I read that wrong. Certificate of interest in, certificate of participation in, certificate for, receipt for, a warrant or option, or the right to subscribe to or purchase any of the foregoing, or a blank form of any other of the foregoing.
Okay. Understanding this concept. Wow, man, I'm happy you was able to read all of that. And understand, I can too, but I just understanding the whole science. Well, these are it's like these. If you give me $10, guess what I'm gonna give you? I'm gonna give you a security, which might be a receipt for right to retain any of the interest in the asset transferred. And I want you to understand the whole science behind this. And we're going to go look at the slave concept here. It says evidence of ownership of goods, wares, and merchandise. And B, instrument evidencing ownership of goods, wares, and merchandise. If they trap and trade, slave, acceptable, because each state constitution has a slave provision in there. And then they give you the security indicating the ownership of the goods or the merchandise that they're about to transfer. Isn't that a security of the state?
Yes.
Or private entity?
Mm-hmm.
See, and so the states, since they have an obligation to protect the states and the private entities, it becomes an obligation, it becomes a federal matter, because now we're dealing with commerce. But what a problem with us is we only look at the dollar bill. When the state says that you owe some money and all you're used to dealing with is the dollar bill, why don't you put your exemption on what is called an indispensable instrument? Have you guys ever heard of an indispensable instrument?
No.
No.
Okay, just a second. Anybody got a Black's Law Dictionary? A recent one, a new one, because I'll give you the definition of it. And this is a concept that you guys got to get real fast.
I have 9.
Say that again.
I have 1 through 9.
indispensable instrument. Could you read on the ninth one? Could you read indispensable instrument?
Let me get to it. It's an indispensable instrument. Are we looking up instrument and it's going to be a sub?
It's going to be, it might be under but the definition instrument. It might be under indispensable.
Let me see if I can do a search here.
While he's looking for that, what law was before 28 USC section 513, the one before that?
Okay, I'm lost. What was it in relation to?
Obligations.
Okay, when we're talking about eligible obligation.
I don't know. I forgot.
United States Code 31303.
9303? No,
Yes.
the one after that. It was one right after that.
18 USC section 8. These are
Okay.
obligations. See, because when they go give you this obligation, they know that you're, and I'm being honest, they know that you're a nigga and you ain't gonna understand that obligations is the same as that Federal Reserve note. It's the same as cash. It's the same as it's the same thing. Somebody owes on that account. And what they know is you don't understand that. So they're going to get away with it and they're going to pass a lot of money here. But what an indispensable instrument here, and I try to explain what I'll give you the definition of indispensable instrument. It's a form of writing evidence of interest in an intangible, so necessary to represent the intangible that the enjoyment, transfer, or enforcement of the intangible depends on the possession of the instrument. Okay, I'm gonna read it again. A form of writing evidences of an interest in intangible, necessary to represent the intangible that the enjoyment, transfer, or enforcement of the intangible depends on the possession of the instrument. Okay, now now we're gonna rights, interest. We'll talk about rights and interest real fast. Who has the right to lay and collect taxes? Somebody answer that.
And the Constitution is
Congress.
only.
Okay, Congress have a right to lay and collect taxes. Is the right to lay and collect that you could physically touch?
No.
No. So guess what they have to do? They have to physically put it on a piece of paper. They have to exercise their rights on a piece of paper. They have to put it on a tangible piece of paper, which makes it an instrument. It's an indispensable instrument. It becomes an indispensable instrument laying forth the rights that the United States is exercising. So it's a writing evidencing an interest of an intangible, the right to lay and collect taxes. So necessary to represent the intangible, the right. The right in and of itself is an intangible thing. It's not something that you can physically touch.
Right.
So it represents the intangible that the so necessary that represents the intangible that the enjoyment, transfer, or the enforcement of the intangible depends on the possession of the instrument and of itself. So guess what they did? When the United States or the state, they say, look, we got the authority, we got the authority to tax this nigga. We're going to collect interest on this account. When they actually give you this, they're actually giving you the physical, indispensable instrument that holds the rights to the taxes that they are collecting, because they have a duty to give it to the people. Does that make sense?
Yeah.
So now you have possession of an indispensable instrument with a tax. On the same instrument, you could put your rights. And what are your rights? To exempt the liability. This exact same instrument with your exemption on it carries on their right to tax and your right to exempt. But a court has to see it and they have to put a record for registration. Indicate that it shows rights that's on this tangible medium. It's so necessary that you turn this thing in so that they could see that you're somebody's exemption here. Does that make sense?
Yes.
Okay. Now, what if you lost that tangible, this security here? You lost the security that they gave you, this obligation. Can you make your own? It's not a trick question. Can you make your own?
I think so. Or probably you could ask for a certified copy.
But see, the certified copy, and that what's the important part, or it's not an important part, is so the copy that they give you shows all the avenues or aspects of that obligation,
Mm-hmm.
of the obligation registered in the court, right? However, if you were to take your own obligation or your security, because these are the right, if you make your own security, you could put a private organization on here, and you could put the exemption on here. Now, once you put the exemption on this obligation that you wrote, and says, and then you put the account number that's registered in the court on there. Now, did you give them an indispensable instrument bearing yours, consequently the right to exempt the liability? Now, a court can look at that as the same as them an obligation that they gave you. Now, that's a private or corporate surety bond, as indicated in the statute dealing with when it says it's the same as giving a corporate or personal or corporate surety bond.
Hey,
So now,
could you repeat that one more time, please, sir?
Okay. We went to 31 USC 9303. When we went there, we described it. It described the situation where given a eligible obligation is the same as giving an eligible obligation is the same as giving a surety bond, which can be used the same as giving a corporate or personal surety bond. I don't have this. Okay, it says corporate surety bond, a certified check, a bank draft, a post office money order, or cash. Okay, so if you give them the obligation, it's just giving them any of those. But in most cases, we're giving them the eligible obligation by giving them their obligation, the eligible obligation that they give. But they said it's the same as if you give them a personal or corporate surety bond. And then if you write on a piece of paper and you give them your exemption, and you're certifying, I hereby certify under penalty of perjury, and I promise that you could claim my exemption to defray the liability assessed on this account and to furtherance of the release of the interest in this case to me on such and such date. Now you've effectively given them a surety bond, authorizing them to use your exemption. Is it a bond? You certified it under penalty of perjury. Therefore, if they have a surety bond, a personal surety bond.
Yes.
You, as somebody that's never or you're unsure of yourself, what you would tend to do is you'll be afraid to actually exercise your rights. But if you're under pressure and you actually know what the hell you're talking about, they can't stop you because everything is in the law that's indicating that you are entitled to do this. It's just that you had a question.
I think why they give you time, right? And they delayed for like say if you have a case, they delayed for 2 weeks, and you never do anything about it.
We're gonna go to 28 USC, but after this we have to kind of like cut it loose, but go to 28 USC section 27. Just a second. I gotta go to 27. I think it's 14. And this will confuse a lot of people based upon the fact that the statutory provision is talking about post office, but when in all actuality it's not dealing with post offices at all. Wait a second. Just a
22
second.
USC 2714. Denied passport and certain convicted drug traffickers.
No, this is 28. Just a second.
You have 22.
We're going to type 8.
28, my bad.
And I might have said it wrong. It's 27. Title 28, 27.
14 is what you said.
Now, because it says post office, but it's title over property. It's 13.
Title 13, 2017.
Title 28, 17. Excuse me. Title 28, 27, 13.
Is it trial of ownership of property?
Now here, this is the kicker. These sections, if you read these sections, this is talking about getting you free and stuff, but a nigga can't see this because they're not paying no attention to it. It's 28 USC section 2713. Because they're locking people up for the debt. It's not the offense, it's because of the debt obligation. And if you go to 2710, they're going to break it down, and you just have to understand how they're doing it. Since they say in postal, a person's not going to get it, but I could actually break that down too. But it says not later than 20 days before the return date of warrant under section 2712 of this title, a party who is attached, the slave that's attached, on notice to the United States Attorney may file a plea in abatement. For one, they can file a plea in abatement. One, deny allegations in the affidavit. Two, or deny ownership in the defendant of the property attached. In this section, they're saying you have 3 ways to plead. Your public defender, he tells you to deny the allegations in the affidavit within that first, that first 20 days. What the attorney tells you to do, he says, plead not guilty, and I'm gonna come downstairs and talk to you.
So he's trying to bury you.
Yeah, because guess what you're doing? Guess what you're doing now? You're denying the allegations in the affidavit. They said the nigga had the bullet.
Right.
So now here, the first way you could plead, it says, what does it say? The party the party whose property is attached on notice to the United States Attorney may file a plea in abatement. To abate means to eliminate, nullify, or squash out dealing with the merits of the case. Of the case meaning the case, what the merits of the claim. The claim is the right to payment, for the rights to payment. But if you were to nullify that with a plea and abatement exempt, offsetting the liability, the case could be closed out initially. But your public defender who wants an interest, but in all fairness, not all attorneys understand this. But what he's trained to do is to give you a plea what his duty is to tell you to deny the allegations in the affidavit within the first 20 days. So when you go into this courtroom and they say, plead not guilty. Then in open court before this judge, you say, I plead not guilty. Okay, you denied the allegations in the affidavit, authorizing the judge to take over the controversy. Now they take over the controversy on if the nigga did it or did not do it, because guess what? You denied the allegations in the affidavit. And you know damn well you had the bullet. It was in your pocket. You was chewing on a bullet too. So now understand the science here. You really had that. Now this is the catch, and no one's really paying no attention to this. It says, or deny ownership in the defendant of the property attached. If you guys can read that, or deny ownership
Yes.
in the defendant
Saying
of
that
the property attached. Say that again.
I'm saying that you're denying that it's your property. You're denying, like you're releasing the property to the United States.
But listen to how they're saying this, and I want you to understand it, because are you the defendant? I'm asking you that question.
No,
you're not the defendant. Okay, but now here you're the claimant, but you ownership in the defendant because the defendant is the artificial person whose name the property is in.
Oh, okay, I see.
See, while you personally, you're sitting up here thinking that they're talking about me. I committed this offense, right? They're not talking about you. They're talking about the defendant. The defendant owns the property. Subsequently, you're the property, and you act as the surety for the defendant.
So one last thing, Shake, before you go, because I know that time is up. But you said that the plea and abatement can be made based on your denial of ownership as a defendant, but then you also used...
Fuck no. Just understand, I didn't say that. the plea and abatement's eliminating the case. But you could beat a case if you're not if in essence you could beat a case if you start saying I'm not the defendant. I'm a human being. And
Right.
they can't move forward. And you
And
and
folks,
there's
you
say that
deny,
again?
but I just want you to repeat what you had said right before this interlude. You said, you know, we can deny ownership in the defendant of the property attached, and then you mentioned that set off, that exemption is where you blended it together in one statement, real smooth.
There's three ways to plead within that first 20 days. Okay, the one that we're dealing because the attorney doesn't know no better, or he's just selling a nigga. He's going to have you deny the allegations and the affidavit, authorizing the court to have a trial over the issue on if you committed the offense or not. Or then there's in this next paragraph they talk about issue. An issue doesn't only mean an issue like an argument or whatnot. An issue is also a legal term and a commercial term using for negotiable instruments that's transferred. So the issue before the isn't if you committed the or not. The issue is this damn indictment. The indictment itself is the issue. So now, here, this is an issue that you're saying, wonderful issue here. I love this issue. I'm claiming this stuff. I'm claiming it. I'm gonna use my exemption to defray the liability on this account so that the property is released, and I'm entitled to collect the interest on this account. And what that does, that defeats that abates the actual case on locking the person up in prison. Now, that's one way, but your attorney, he strictly tells you to plead not guilty. You could abate it by using it. Or the third way, deny ownership in the defendant of the property attached. If McDonald's owns property, McDonald's is a corporation and it owns property. Do you understand that? Well, how are you going to bill me for some property that McDonald's owns and I don't own shares in McDonald's? So now you can deny ownership in McDonald's if you don't have nothing to do with the interest in McDonald's.
Right.
But in this particular situation, and you want to stay away from this one because the property of the defendant is attached subsequently is you. If you want to deny ownership in the property defendant attached, then you want to deny ownership. If they have possession of that property and you're saying that you don't have nothing, they technically, some levels, they could keep possession of the property subsequently, which is you. Does that make sense?
Yes, sir. But
Okay.
now you're making a difference between the word defendant and the words property attached.
Yes. Let's read what it says. Or deny ownership in the defendant. The defendant is a corporation. We all know that.
Mm-hmm.
Of the property attached. The defendant is technically when you stood up and you said that you're standing up here for the defendant, technically you became property of the defendant. Because what would McDonald's be without its property? McDonald's is just a name. But the sureties, the property, the interest that comes along with McDonald's becomes the property of McDonald's. What gives McDonald's value? Does that make sense? Because McDonald's is just a name. So I'm not gonna deny ownership in the defendant. I'm not gonna deny ownership in the defendant of the property attached because the defendant has ownership of the property. And I'm sitting up here claiming that that's my shit. I have an ownership interest in the defendant and his property. Does that make sense?
Yes, sir.
So now the next section here says the court, upon application of either party, shall order a jury of the issues. Now the issues. So now here you a nigga sitting up here saying not. They're gonna make it you saying not guilty or not, and guess what they're gonna prove? That you're guilty. But the real issue is the negotiable instrument that's really sent before the court. So if you're the accept for value and say, hey, I'm the rightful owner of this. I'm the owner. I'm accepting ownership. If you're to check the registry, I have the ownership interest. I register ownership. And as the owner of the property, you can get the property released. What does it say? A party claiming ownership of the property attached and seeking its return is limited to a fourth section, but his right to an action for trespass or other actions is not impaired. I want you to understand what you're saying here. And if you're to read these sections that come along with this, they're going to, if anybody caught a criminal case, you'll see how all these rules in this section that applies to a criminal case, including the release. The release about where this section is at. I think it discharge. The discharge coming in 2717, but it's past that time, guys.
All right. Well, inshallah, we thank you so much for your care and consideration. Again, we're going to post your Cash App for any tip. I know we got a tip for you that we're about to send your way in a second. So we thank you again, Sheikh, and we look forward to you telling us of your availability for the future so that we can continue this education for the benefit of our group and the people that are interested. So on that, we're going to tell you alaikum, and we're going to close with chapter Fatiha from the Holy Quran, unless you have something else to say.
That'll work.
Before you comments, I just want to make a comment. I think everybody has that same concern. Are we going to receive a copy, because I came halfway through, I think.
Yeah, make sure that you can get a link to the proof of the paperwork in the chat, and then if you leave your email, I believe I know your voice from the sister Malika and Lawful Living.
yes, that's me.
So if you send your information to Haqqani Consulate, that's me, or you can, I'm an ambassador on Lawful Living, and we're going to provide these things, okay?
I'm gonna reach you. No problem. Thanks.
Yeah, I want you guys to understand. I love, and we could start looking at it from a practical nature on how the court system and the system actually works. So why you can see how they could do such evil things, because it's all within the confines of law. So if it's within the confines of the law, you could use it. So, but the problem with us is, guess what we do? We think we know the law, but never ever look in the law. But once you start looking in the law, you can see how they get away with this stuff. And you also remedies. Each law that I showed you guys today, there's more in-depth law in these sections. And then when you start looking at it from you being a winner, you'll start to see, oh, hold on a second, I'm not gonna argue this dumb shit. Let me use this. And then they'll fall silent, because then they'll start realizing you're understanding what you're doing.
Yes, sir. Well, that's what we want. We definitely want solutions and not problems,
Right.
So on that note, Sheikh, we bid you adieu. Assalamu alaikum. And we're going to commence. We're going to finish with just the way we started, with the first chapter of the Holy Quran. أعوذ بالله من الشيطان الرجيم بسم الله الرحمن الرحيم الحمد لله رب العالمين الرحمن الرحيم مالك يوم الدين إياك نعبد وإياك نستعين اهدنا الصراط المستقيم الذين أنعمت عليهم غير المغضوب عليهم ولا الضالين آمين.
Ameen.
Assalamu alaikum wa rahmatullah. Good to see you.
Wa alaikum salam wa rahmatullahi wa barakatuh.
Wa alaikum salam wa rahmatullah.